So again, just to welcome you all to Bristol Law Society's weekly webinar today in association with the Legal Ombudsman and looking at best practice complaint handling. You know, let's be honest, nobody wants to have to deal with complaints, but it's nature of the business that occasionally happen, and obviously resolving them in a way that you know, aids resolution is the way forward. So if I can welcome our speaker, Jason Chapman. Jason is an experienced commercial manager. He's worked across, was an experienced commercial manager, I should say, working across different sectors, has a wealth of experience at the Legal Ombudsman, and joined as an investigator back in 2010 and was appointed as an ombudsman in 2013. So plenty of experience to draw on. And you know, today's webinar, as mentioned, is going to cover the role of the Legal Ombudsman and the most recent data drawing data showing the complaint themes and trends. So Jason's going to be sharing best practice tips to avoid complaints being made, as well as how to effectively handle complaints when they do arise to aid resolution and make sure that they don't escalate. So there's going to be an opportunity to ask Jason questions at the end. So we're going to be recording this webinar, so we'll be able to send you a link to that afterwards so you can watch it again. We'll also send you a copy of the slides. I think there's quite a few here, so don't worry about having to make too many notes. You'll see there's a Q&A and also a chat function down at the bottom. So as we go along, if you've got any comments on anything that Jason is saying, or there's questions that you want us to pick up at the end, then please do put those in there. Yeah, as I say, I will pick those up at the end. But I think without further ado, I'll hand over to Jason, and yeah, let's get going with today's webinar on best practice complaint handling. Thank you very much, Jason.
Thank you. Good afternoon, everyone. Thanks for spending the time today to listen to me to talk about this subject, and thanks to Bristol Law Society for allowing us to present to its members. As said, I've been an ombudsman now for about 9 years. There's two sort of aspects to my job, really. Firstly, I determine complaints that's been brought by members of the public against service providers. But secondly, and no less importantly, is I sort of share best practice with the profession, educate, inform, and that seems by our board to be a very important part of what we do. So today what I'm going to do is, because I'm aware that sort of the knowledge of our organisation does vary across firms. Some people know us very well because they deal with us frequently, and others less so. So what I'm going to do is explain where we sit in the general scheme of things, and then give you an overview of our business process. Then after that, I'm going to talk a bit about how we can prevent complaints. It's not always possible to do so, but there are certain things that we see recurring in the work that we do, that we think, you know, this really shouldn't have got to the stage where it's with us. It could have been resolved before. How to best respond to complaints, because again, we see a sort of varying sort of quality and range of firms' complaint responses, some of which are good and some of which are not so good. And how we would go about determining complaints, and that's quite useful we find for firms as well, because they can base their own sort of way that they determine complaints on how we would do it. How to put things right, and then because it's quite an important thing for a lot of firms is how we apply case fees, because obviously, you know, this is can be a bone of contention, and it's just to explain how it is that we go about things. Finally, we always put in a bit about managing challenging customers, because we do realise that, you know, this can be a problem for firms, and we just wanted to share sort of best practice tips and hints on how to best do that. So without further ado, I'll sort of move on to the first section of it. It's really just about how we function and who we are. So we're an independent ombudsman scheme that resolves complaints about lawyers in a fair and effective way. We aim to be open with both lawyers and complainants, and decisive when tackling complex issues. Now, we deal with a wide range of service providers. 85% of our complaints are about firms of solicitors, but the other 15% is split between barristers, conveyancers, Silex executives, notaries, and some accountants who deal with probate matters as well. Our purpose is to resolve complaints impartially, promote service excellence, and be a champion for best practice for the benefit of consumers, service providers, and in the interests of business and society. Now, it's important for me to be clear at this point, we're not consumer champions. I always say in these presentations, I'm not Martin Lewis. I don't stand on the side of the consumer. We're very much independent, standing in the middle. what we do is we determine complaints based on the evidence and comments from both sides in an impartial way, and it's this very much an evidential based process looking at what's happened. The test that we use when we determine complaints is the balance of probabilities. It's what's more likely than not to have happened, and that's based on the evidence and comments that we see. As I said, I mentioned at the outset, part of our role is to inform and help the profession and sort of highlight trends and themes of things that go on that we see, and to give tips and hints on how firms can address them. We've got a 4-stage process: assessment, investigation, resolution, and decision. When we get calls coming in for our first contact centre, what we will do is we will assess whether they are complaints that we could potentially take on. Just to give you an idea of sort of the scale of this, we receive about 70,000 contacts a year from members of the public. That translates into roughly about 6,000 complaints. There's a lot of calls that we receive are either signposting issues, so they're not really for us, or so we send them the people to where they should go, or they're for premature complaints, so people are coming directly to us without firstly complaining to their service provider, which we wouldn't accept a complaint on that basis, because obviously it's fair for the service provider to try and resolve the matter themselves before we get involved. And there's a various sorts of a variety of things. When I started, for example, we were 1 digit away from the TV license renewal online telephone service, so we used to get a lot of telephone calls about people wanting to renew their television license, which we don't get anymore. But to put it in context, we did for every 10 calls we get, it's generally about 1 complaint arises as a result of that for investigation. So what we do when we receive the call, we assess it. We find out firstly whether they complaint is about a regulated service provider, so so falling within our jurisdiction. Determining whether the complainant has received a service, and whether, like I say, a complaint has been made to the service provider in the first place. Is it within our timescales? And then and having determined all that, we then do a triage on the complexity of the complaint to make sure that it goes to the right section of our business to progress it into investigation, because we have sort of low, medium and complex cases, and the complex cases go to different, more experienced investigators to deal with, who are more sort of used to dealing with those. The more sort of transactional, simpler stuff go to another area of the business, who are sort of hold higher case holdings and sort of progress more stuff through quicker. When we pass the case for investigation, allocate it for investigation, what we do what we're doing at the moment prior to that is that we are trying to contact firms and complainants to try and negotiate settlements before we get to the stage of investigation. Part of that is reason because of the pandemic, we've had a sort of a larger sort of backlog of cases because of the way that our restrictions on dealing with cases. So what we're doing now is we're sort of more proactively going and trying to get parties together before we get to an investigation stage to see if we can resolve things informally before our involvement. Because of course at that stage there's no case fee applicable, so that won't be an issue. And we found that we've had some quite good success with that sort of initiative that we've done, and we're getting a lot of complaints sort of being resolved before they get to the investigation. Once it is sent for an allocated for investigation, it goes to an investigator. The investigator will scope the complaints, and by which I mean will ascertain and determine with the complainant what it is they're complaining about. I'll talk a bit about this later, but it's not always easy to do. So what we do is we sort of always box it off before we start the investigation, so we know exactly what it is we're investigating. And from that, we will request any comments, representations from both parties and the relevant evidence. The investigation takes place based on that evidence and comments, and on the test of balance of probabilities. We are looking for reasonable service, not perfect, not gold standard, just what is reasonable. And the evidence and comments will be used to determine whether the service was being reasonable. If it's not, then we have to determine whether there's been any detriment or impact on the customer, and if there is, what can we do to put that right. The point of the output from our investigations, whether it's involved informally or formally, is to try and put the person back in the position they would have been in had the service been reasonable. we're not sort of set up for every case to go through to a formal ombudsman's decision. So part of the investigation process will, again, in the resolution section of it, will be to try and agree a negotiated outcome between the parties. If that's not possible because the parties are too far apart, our investigator will produce what's called a case decision, which is a formal report setting out the evidence and determining the complaints, which then the parties get the chance to comment on before it's sent to an ombudsman, and then the ombudsman will make the formal final decision. And that, if it's accepted by the complainant, is binding on the firm. So that's the kind of the way that we work. In terms of preventing complaints, like I say, we received received about 6,000 complaints last year, and we investigated 4,500. Part of the reason for the discrepancy there is the sort of the COVID issues. We were sort of working out of office, and we had a reduced capacity during that time. So we've been steady for about the past few years apart, outside the pandemic, of about 6,000 complaints a year. So what we're keen to do as well is to coach firms on and provide feedback and learning on how to prevent complaints, because a lot of the complaints that we do see coming through, we feel could be prevented. If you look at, we've got slightly out of date. We're waiting for our 2021-22 data at the moment. So apologies, this is still current data, but this gives you an indication of what it is that people are complaining about. The most common complaints are a failure to advise and delay and failure to progress. Now, although we found this was a more common thing during the pandemic, firms failing to progress or delaying matters because, again, they were furloughing staff or didn't have access to their offices, this isn't out of step with previous years. It's still the most common basis for a complaint is the failure to advise, the delay and the poor communication. In terms of costs at 14%, what I would say about that is that this is a split between costs information, so people not being told where they're being charged, which is partly communication, but we sort of categorize it as being poor costs. But we also determine complaints on the costs themselves, so people feel that they've been overcharged or things have been too expensive for them. And we don't make any determination on value for money. We appreciate that firms have different charge out rates, and that might be because they have different specialisms, and it might be appropriate for some firms to charge more than others because of the type of work that they're doing. But the final main of the main five is a failure to follow instructions. Now, in terms of the areas of law, we find that about 30% of our complaints are about residential conveyancing matters. That's not to say that residential conveyancers are doing, conveyancing solicitors are doing a poor job, but it's just the volume of transactions that take place in this country in any given year, and the sort of the issues that might arise that would generate complaints. The next most popular, if you like, area of law is family and matrimonial, which accounts for about 15% of the total number of complaints we get, as does personal injury and wills and probate matters. They're the sort of the next three most common areas of complaints, of law rather. But by far and away, the most common is residential conveyancing. And what we're always mindful of at the Legal Ombudsman is a lot of the time people instruct legal service providers, it's a distressed purchase. In other words, it's people who are instructing firms of solicitors and barristers at difficult and stressful points in their lives. Maybe somebody's died, or maybe they're facing criminal charges, or dealing with an immigration matter that's of paramount importance to them. And a lot of the complaints that we find generate because of the expectations that people have. But part of that can be resolved by reasonable communication and expectation setting, which I'll talk a bit about in a little while. So in terms of the main complaints, delay and costs, we find that a lot of these could be avoided if the communication was better. People come to firms a lot of the time not knowing how long things will take. They have an accident in an RTA and they want to bring a personal injury claim against a third-party driver. They see adverts on the television with people getting 100% of compensation. And when they instruct a firm, they expect to get that compensation pretty quickly. But actually, things can take. We know that things can take a while. It can take a while to negotiate with the other side. Medical evidence can take time to collect and collate. and the whole litigation process isn't quick. So we do get a lot of complaints about delay, but what we find is that, you know, if firms have provided a realistic timescale for the work that they were going to do at the outset, then it can sort of avoid a lot of problems later on. And if something happens during a retainer, be it litigation or some dealing with a will or anything really, if there's a delay that sort of occurs during a retainer, firms don't often explain why that is and how long things are going to take. And quite often it might not be any fault of the firm. It might be just a case that, you know, they're waiting on some third-party evidence that's not forthcoming and they've chased it, but they're not having any success in obtaining it. But a lot of the time they don't tell the customer what's happening, and that generates the complaint about delay, because the customer then thinks, well, it must be the firm because I've not heard anything. So like I say, a lot of the time we do see a lot of cases where firms have delayed matters, especially during COVID, because and again, we understand the reasons that firms haven't necessarily had access to their offices or their paperwork, and they've been furloughing staff, so they've been on a reduced headcount, so they're not easily able to progress matters as quickly as they would have otherwise. But again, if that's the case, we would expect firms to be telling their customers what the issues are and what the delay is going to be and how long things are going to take. So delays are very common. The other thing that we see a lot of is costs complaints. A lot of the time, customers this is generated on the final bill. Customers find that they're getting charged an amount that they didn't expect. And we find that, you know, just reasonable cost advice throughout the retainer can sort of prevent a lot of these complaints. We would always expect a cost estimate to be provided at the outset, although we appreciate with certain areas of law, such as litigation, it's just not easy to do, because it depends on the ability and intention of the other side to settle, how long things are going to take, whether it's going to be negotiated settlement or through final hearing at court. It can have a huge effect on what the ultimate bill is going to be. But what we would expect firms to do is just provide a sort of an indication. If with a staged estimate is fine, whether it's saying, you know, for the first reading of the papers and initial negotiations, it's going to be so many thousands. Mediation, it's going to be an additional X, and then if it goes to court, it could cost you up to, say, £50,000, £100,000, whatever that is. Just make the client aware of what the costs may be. And if you provide an estimate, and estimates are just that, we realize that, you know, it's just a best guess of what the likely costs are going to be in the circumstances at the time that's given. If they are going to be exceeded, and there's good reasons why that might be, we would expect the firms to be telling the clients that the estimate's going to be exceeded, and then set a new estimate. That's not poor service. That's just the way that things happen in retainers. So we estimate, we accept and recognise that. The other thing we see a lot of is billing over long periods. Just so a retainer will go on for 3 years, and there'll be no billing, and then there'll be a big bill at the end, which it's not easy for customers to pay. We would always say, you know, if there's a possibility for regular billing, then that's always preferable. Set out the frequency in the client care letter so the customer knows when they can expect to be billed, and reevaluate the position every 3 to 6 months. We also find that there's not always often a clear explanation of agreements, such as conditional fee agreements, and explaining complex offers such as Part 36 offers. And I'll talk a bit about that later, because I've got an example of where that's gone awry. But the main one that we find, main area in which we find that complaints could be avoided, is in communication. A lot of this, and on this slide, it should be fairly obvious, but we don't see it. Ensure communication is clear and customer friendly. We see sort of very client care letters that are very jargonistic, very difficult to follow, very lengthy, and customers who often haven't engaged with the firms before don't know what to expect. So if you make the communication as clear as customer friendly as possible, we find that to be better. Explain the legal process, because a lot of the time the customers just won't know. Like I mentioned with the personal injury claim, they won't know how. They just think that somebody's going to write a check and that will be the end of the matter. They don't understand necessarily that there might be medical appointments, medical evidence needs to be obtained, negotiation with the other side, and then sort of offers coming backwards and forwards. So explain what the customer's options are, and states, because obviously, you know, sometimes customers may be able to example settle a claim or progress it on, and just explain the risks and what would happen and the timescales involved and the costs involved in all those options. The other thing that we find a lot of, especially in litigation matters, is changes of fee earners, which are, again, a lot of the time beyond the firm's control. People leave, people get promoted, moved into different departments, and claims get moved from one solicitor to another. But we find that firms don't always tell the customer that, and people just don't know what's happening with their claim, or don't know who to contact, and they phone a firm and the person's no longer working there, and that can generate complaints as well. And updates and response times, obviously, we realize that, a lot of the times if nothing's happening and you generate a letter, then that's just a cost to the customer to tell them that nothing's happening. But we do find that a lack of update and information generates complaints. So we would always advise for regular sort of, say, monthly updates, even if it's to say, look, we're still waiting on the other side for the evidence, or we're still sort of waiting on this, or we're still waiting for the court for a court date. It's just letting customers know that even if there's no progress, that things are still going on and the firm is still dealing with the matter. And finally, we would also say that explain when customers' requests aren't reasonable, because we do get customers making unreasonable requests. For example, requesting that certain witnesses are called in criminal matters that aren't appropriate. It's not poor service to say no to a customer, but it is poor service if you don't intend to follow their instructions to tell them why you're not doing that. So we would always just say, explain if something's not reasonable, explain why you can't do what's being asked, and we never have an issue with that. So at this stage, I'll just say, have a think about your own firm. Do you think your firm does enough to prevent complaints, and what initiatives do you have in place? And just have a, is everything as easy as it could be to complain, and is your sort of communication what it needs to be? What I would say at this point as well is we have a technical advice line. If you're ever wanting sort of help, advice, guidance on how to sort of deal with matters, even before a complaint is raised or during a complaint or afterwards, contact us and we will provide a response to you within 5 days. And the website address for that is technical.advice@legalombudsman.org.uk. And I think that's at the end of the presentation, but I just want to say at this stage, we do sort of want to engage with the profession as early in the process as possible. So if you're worried that your firm's not doing enough and you could do more, but you don't know what it is you could do, like I say, drop us a line and we'll do whatever we can to assist. So like I say, sometimes it's not always possible to prevent complaints. Sometimes the best firms have the most complaints, depending on the area of law that they're dealing with. You just can't completely avoid them. But how you respond to them and how you determine the complaints is important, because that sort of sets the tone, and a complaint that's responded to well can resolve matters at a very early stage, and if not, we will end up dealing with it. So it is a bit of a cliche, but we would say that it is an opportunity for learning, and the old cliche about the complaint is a gift. It does sort of have some truth to it. We find that the Legal Services Consumer Panel Tracker Survey 2021 found that reputation remains the most important factor when choosing a provider, followed by the price, 71%, and specialism of law as 70%. So what we would say that, when you do get complaints, use them as an opportunity for learning going forward, and use the feedback mechanism to sort of determine what went wrong and how, whether there's any opportunities for change in process or the way that you deal with things to make things better for customers, for different customers further down the line. So in terms of what's important, again, some research that we did with the Solicitors Regulation Authority in 2017 showed the discrepancy between what the solicitors felt was the most important aspects of the service and what the customers themselves felt. So the solicitors themselves thought that the most important aspect of the retainer was a positive outcome for the consumer, followed by clear cost information and regular updates on progress. But in actual fact, when we did the research with the consumers, we found that the most important thing to the consumers was regular updates on progress and being told what was going on, followed by clear cost information, and actually the positive outcome, which the solicitors thought was the most important, was actually the least important aspect for the consumer. So it's just worth bearing that in mind, really, that you know that reasonable communication and updates on progress are important to consumers, and by providing those, you can prevent a lot of complaints arising. But we've got to understand why it is that people complain. People complain because they want the feedback and they want to give the firm an opportunity to address the problem. They may wish to vent anger or frustration, or they may wish to help improve service, or they want to help sort out the situation that's arisen. And this says other things as well. And we're under no illusion from where we're sat that people come to raise complaints because they want that the thought of compensation is attractive to them, financial compensation for what's gone wrong. And we find that as well going through our investigations, that people can be quite transfixed on the issue of compensation rather than putting things right. But there are reasons again why people don't complain as well. And because it's time consuming, it's unpleasant, people feel intimidated, especially when they're complaining about legal service providers, because they think that, as one complainant said, well, I'm complaining about somebody who argues for a living, so it's quite difficult. And we do sort of understand that. But there's also a view that they won't be dealt with fairly. Some people are confused as to whether they'll be charged for a firm dealing with the complaint, or they don't know how, which sounds crazy, because you think, well, they will just look at the complaints handling procedure and it should all be there, and it should be, but in some cases it's not. We found that it's not available, even though it should be. Because the SRA Code of Conduct says that you shall establish and maintain or participate in a procedure for handling complaints in relation to the legal services provide. The transparency rules also require the firms to have their complaints handling procedure on their website. Some recent research we've done found that not all firms are doing that, or if it's there, it's not easy to find, so people are being put off complaining. So just have a think about where it is on your own firm's websites and whether it's easy for people to locate. And in terms of the section 8.3 of the Code of Conduct, firms need to ensure that clients are informed at the time of writing of their right to complain about the services and the charges, how a complaint can be made to whom, and any right they have to make a complaint to the Legal Ombudsman, and any such time that they can make such a complaint. So that's just to inform complainants about our existence and the fact that they can bring matters to us if they don't reach resolution with firms. And although firms are sometimes reluctant to involve us, and the thought of the Ombudsman getting involved is terrible and they don't want it, sometimes it can be quite good for firms because it enables them to sort of draw a line on it and pass it on to us, and then they don't spend hours of otherwise fearing time dealing with a complaint that when we can deal with, especially if there's nothing wrong really. And we will, like I say, engage with firms and try and resolve matters for them and for the complainant as well, to try and to sort of bring an end to matters. So like I say, just if you look at your client care letter and your complaint handling procedure and your complaint responses, just make sure that the signposting is there. If it isn't there, we would under our scheme rules, we would always charge the case fee. And we've had complaints come through to us where nothing's gone wrong and the firm's conduct has been absolutely fine, the service has been reasonable, but we've still had to charge the case fee because the person wasn't made aware of their right to bring the matter to the Legal Ombudsman. So just bear that in mind if you just want to check your own complaints documentation to make sure that signposting is still there. So I think a lot of the problems that we see is that sometimes it's not easy to understand when a complaint has been made, and so we get complainants coming to us that say, oh, I've complained to the firm and I'm not happy, so I want to bring the matter to you. And then we come to the firm and the firm will go, well, we don't recall a complaint having been made. But actually, when we look at things, a complaint has been made, it just hasn't necessarily been picked up. And it is quite difficult. It would be ideal, in an ideal world, you'd always get a letter with a big sort of red formal complaint heading on the top, and it would set it out so you can just respond to it. It's not always the case. Our scheme rules require expression of what's termed an expression of dissatisfaction. That doesn't even have to be in writing, because obviously, you know, some of the complaints we get, people have learning difficulties, they can't necessarily express themselves in writing particularly well, so we would accept a complaint in that's provided verbally. But like I say, it's just not always easy to pick one up. So when you get a complaint, if you think about it, when you'll get your customer communicating with you and you're not sure, you think, just listen to them, determine, is this a complaint being made here, and if so, what are the reasons for it? If you do pick one up, move to the next stage on the slide, number 2, inform, where just acknowledge that the complaint's being received, explain the process, and reassure the complainant about any worries that they might have. They might think they might be dropped, or they think they might be charged for the time taken to investigate the complaint, which obviously won't be the case. But you know, lots of the times things can resolve if you say, you know, don't worry, we'll sort it out. We'll try and resolve the complaint if we can, but we'll certainly provide you with a response as to what our findings are. Lots of the time, it can sort of take the heat out of a situation. And then when you do your investigation, you respond, set out what you found out. If you found things that have gone wrong, explain how you put them right, and send a response within 8 weeks. And it's necessary, and then signpost the matter to the Legal Ombudsman, just so we're, you know, that the complainant's aware of the fact that we're here and we can sort of dictate things on if the matter remains unresolved. And finally, like I say in the earlier slide, if you could take any learnings from it, it's always positive. Is there any lessons for staff or the firm, or the processes, procedures? Did things go wrong because there was a lack of communication that could have easily been resolved, that you could take things on and deal with it better next time? And so just use it to your own advantage if you can. But like I say, recognising complaint isn't always the easiest thing. Like I say, if you get the big sort of the formal complaint letter or the email to them, that's very easy, and you can just deal with that in the same way via a formal process. But there's, on the left hand side of this particular diagram, you could see sometimes you might think, well, is the customer rate just raising a query, or I've received a bill, is this right? Is that a complaint? Well, no, it's probably not. It's probably an inquiry that can just need an informal response. If they're raising concerns, they might just be raising concerns, they might not be complaining. It's very difficult. The advice that we always give is, if you're not sure whether somebody's making a complaint, the best thing to do is ask them, are you making a complaint? Do you want us to provide you with a copy of our complaints handling procedure? Do you want to escalate it and progress it as a complaint? Sometimes they'll go no, and that will be the end of it. Sometimes they might say yes, so you can start that process, but you're starting from a position where you weren't sure, but now you are. So that's what we would say. We would always say, just like, if you're not sure, either treat as a complaint or ask the customer if they want to progress matters as a complaint. Then we would never criticise a firm if the matter then came to us. So in terms of what a good response looks like, we see a variety of complaints responses. Obviously, like I say, on an annual basis, we deal with about 6,000 complaints. So we see 6,000 formal responses to complaints. Well, some firms unfortunately don't respond, but the vast majority do. But we see a vast sort of a wide variety of complaint responses, some of which are very good, and I'll give you an example of one of those in a minute, and some of which aren't so good, and again I'll do the same. But there are sort of some general points that I'd sort of raise in terms of making sure that the response is as good as it could be. Firstly, say keep it simple, keep it clear, keep it jargon free. Don't use legalese. We find that can be quite either intimidating and annoying for customers as well, because sometimes the customers think that you're trying to get one up on them because you're a legally trained person and they're not. Keep a professional and courteous tone. That sounds obvious, but we often find that, you know, understandably, sometimes solicitors get emotionally invested in complaints. They're being criticised and they don't accept the criticism, and sometimes we find that the responses can be somewhat defensive, or worse, sometimes passive aggressive, or even on occasion outright aggressive towards the person making the complaint. And we'd also say, just take a step back, take the heat out of the situation, and provide a professional response, because it's more likely to resolve matters than sort of just firing off something that's, you know, gives some of the anger back that the legal service provider's feeling at the time. Make sure it's provided in a timely way, and say that you appreciate the feedback. because, like I say, it's just that the person's taking the time to explain why things are wrong for a number of reasons, admittedly, but you know, they have taken that, make that effort to do that. And just, you know, if you let them know that you appreciate the feedback, again, it can take a lot of the heat out of the situation. Be clear on what issues you've considered. Again, if you're not sure what the complaint is, and sometimes we get stuff coming through all the time, which where we get sort of streams of consciousness on handwritten bits of paper, or sort of long sort of rambling discourse about everything that's gone on, and it's sometimes difficult for us to understand what it is that's being complained about, which is why, as I said earlier on, we go through a scoping exercise where we contact the complainant and say, you know, this is our understanding, is this correct, is this everything that you want to bring to us? We'd advise firms to do the same. So if you're not sure what the complainant's wanting to complain about, because you've got a, like I say, just a long rambling sort of 10-page letter which sets out all his problems in all areas, and you're not quite sure, go back to him and ask him, what is it you're asking us to consider? What is it, the complaints that you're raising? And then be clear in the response what it is you've considered, and determine those complaints to say whether, you know, you're upholding them or not upholding them. In terms of your conclusions, if you disagree, that's absolutely fine. A lot of the complaints that we see, that firms have done nothing wrong. But if you are disagreeing and you're not upholding, explain why you're not upholding, and provide that sort of that reasoning so people are aware of it. If you are agreeing with the complaint and upholding it, again, acknowledge that something's gone wrong and explain why you're upholding it. The next one on the slide is, don't be afraid to apologise. It's not an admission of liability, Scheme Rule 521. Now, this is more contentious because I appreciate that some PIA insurers don't like policyholders to provide apologies, because it could be deemed to be an admission of liability. All I would say is, for our scheme, an apology is not an admission of liability. Our Scheme Rule 521 sets that out clearly. But if you're in any doubt as to whether you are able to apologise where something's gone wrong, I would just say contact your insurer and ask them, and they will be able to advise you. And acknowledge where stress and inconvenience is caused. Sometimes the matter is stressful and inconveniencing anyway. If you're having to deal with a criminal matter because you've been arrested, well, that's stressful in itself. And we will always look at the matter in terms of the complaints and say, well, actually, you know, if somebody's getting divorced or somebody's getting prosecuted, there's going to be a level of stress anyway. And what we would be looking to determine is whether the firm's service has exacerbated that, or whether the firm have done nothing wrong, and the stress is just purely the circumstances of why the person's come to the firm in the first place. But you can acknowledge that in a response, and we do find it's a positive thing when it's received by the complainant. If you want to trying to put things right, whether that's by paying an amount of compensation or doing extra work or reducing a bill or whatever, have a think about what, and I'll talk about a bit about remedy in a bit, but what you can do to put things right. And then set out the next steps. What the options, if the customer disagrees, is that the end of the process? If it is the end of the process, you need to say it's the end, it's the final letter or final complaints response, and then signpost to the Legal Ombudsman. It's at that point that we have our time limits, and we expect the complainant to bring the matter to us within 6 months of the final response. But the final response has to be clearly the final response. So if it doesn't say it, and then there's some supplementary correspondence going on afterwards, backwards and forwards, it's difficult for us to determine which was the final response. So we would take it from the final letter, and sometimes it was intended that a letter 4 months earlier was the final response, so the person would be out of time to bring their complaint. So it's very important for you to just sort of, if this is the end of the complaints handling procedure, to make that clear to the client. So we've done lots of research on sort of language used in handling complaints. It won't be surprised to anybody that the language used has a significant impact on the outcome of the matter, whether it's accepted by the complainant or not. And service providers increase their chances of resolving matters at first tier if they do respond formally and professionally, use easy to understand terms, reassure customers, and apologise when needed. We do see, like I say, we see in terms of an adversarial collaborative approach, we see both really. We do see a lot of the left-hand column with firms saying, no, you're wrong, being defensive, digging in heels. We also see a rigidly defined complaints process with many steps, which is used to frustrate or dissuade people from progressing their complaints. I dealt with a firm where there was an 8-stage process where you complain to your fee earner, then you complain to the head of the department, then you complain to the managing partner, then the managing partner would provide a response, and you'd have to go to the next stage was around the table meeting with the complaints handling partner and the fee earner. Then if you weren't happy with that, you could take it to an independent barrister in a chambers who determined the complaint, and if that wasn't accepted, then it would go to the head of chambers. And it was just this ridiculous process that went on for months and months that was designed to try and put people off complaining. We don't accept that to be reasonable. We just want to see complaints handling procedures where people can easily bring a complaint, have the complaint responded to, and if there's an appeal process, then that's fine, but then ultimately they should be able to quickly bring the matter to us if they're not remain unhappy. Complicated terms and legal language we see a lot of, and I say an adversarial approach does destroy future relationships. They're not likely to ever come back to you again. Research that we've done finds that people who complain and have the complaint agreed and resolved are more likely to go back to that firm to use them again than even if they hadn't complained in the first place. And outcomes reached by an adversarial method, unsurprising to anybody, are less likely to be accepted. But if you do the opposite approach, which you're open-minded, inquiring, listening, exploring ways to find common ground, you communicating in plain English with clear expectations, and it's treated like a problem to be resolved, everybody can win, and future relationships can be preserved. And resolutions reached amicably are more likely to stick, so it's less likely to require our involvement further down the line. Here's an example of a good complaint response. It's quite wordy, so I won't read it through, but everybody will get a copy of the slides, so you can look at it at your own leisure. But it's a good response. It leads with an apology. It acknowledges the issues, it explains the finding, it doesn't offer a remedy but explains why there's going to be no remedy. Feedback's provided, and it sets out what the changes process they're going to adopt going forward as a consequence of that complaint. So this is sort of really what we are looking to do. It's a professional response, and this was something that we would determine to be best practice in terms of complaint handling. On the flip side, this is a different firm. When I undertake a complaint investigation, I do so using my extensive experience in the profession to reach the correct decision. Well, that's his view, isn't it? It's his view that it's the correct decision, but the complainant had a different view. So your expectations here were unrealistic. You will note that all the fees are listed at clause 8. I've confirmed no refund is due, nor are there any grounds for a complaint. If you wish to escalate the matter to the legal ombudsman, we are fully prepared to defend ourselves. So you can see it's very adversarial, it's very defensive. It's basically saying that there's no grounds for complaint. They've come to the correct decision. It's not sort of treating the problem as to be resolved between the parties, but to be brought together, and so everybody can win. But the one that we see more commonly than that, however, is no response at all. We find that a lot of firms just don't bother to respond to complaints at all. There might be reasons for that. They might have closed, so they might not be trading, but we do see firms that just get response complaints, just don't bother responding. Just a quick one on signposting, which is a regulatory requirement. Just to make sure that everybody can check that they include details of the legal ombudsman in the client care letter and in the complaints process, and at the end ensure the contact details and timescales are in the final response letter. Consumer has 6 months from the date of response to bring the matter to the legal ombudsman. Like I say, if you don't put that it's the final response, that clock doesn't start ticking. We're currently going through a scheme rule review. I'm sure a lot of you will be aware of that, and we're looking to try and change our time limits. At the moment, we can accept complaints about problems that have risen in the last 6 years, or if the matter is more than 6 years old, then the person should have been aware of the problem in the last 3 years. We're looking to change it to 1 year and 1 year, so a year from act or omission and a year from date of knowledge. But at the moment, it's 6 and 3 years, and that has to be communicated in the final complaints response. Obviously, if we get to a point where we are changing our time limits, obviously we'll make that aware, so you can update your your complaints correspondence accordingly. So what I want to talk about now a bit is about how we look to determine complaints, because we would advise firms to adopt the same approach, both in terms of how they determine what's reasonable, looking at the detriment and effects on the client, and coming to a remedy if appropriate, which is fair and reasonable. It's quite important that I talk about this for one reason, which is that the position that we're in as an organisation now is, if we get something coming to us where we consider there's been a reasonable remedy offered by the firm at first tier that remains open for acceptance, we won't look at it. We've always had it within our scheme rules to be able to do that, but we are very rigidly enforcing it now, and we're looking at stuff in the pre-allocation backlog pot, and we're going through to find if first tier offers have been made, and if they have, and we determine them to be reasonable, we're not accepting cases for that case for investigation at all. So not to say that you should always make offers, although commercially you may wish to do that. We wouldn't have ever advised you to make an offer if you don't think that there's been any poor service at all. But in terms of determining complaints and finding poor service and looking to redress it, like I say, I wanted to sort of let everybody know how we go about doing it and what we look at, so you can sort of mirror that in your own processes. Some of the larger firms do this already and are quite successful at it. So it's just something that we wanted to sort of pass on. We've got a two-stage test. Our scheme rule 537 says that the service has to be reasonable in all the circumstances of the matter. So that's the test that we apply. On the balance of probabilities, was the service reasonable in the circumstances? And if it wasn't, did the poor service have an impact on the customer or the outcome of the work? It's entirely possible that the service might have been poor. For example, there might have been a bit of poor communication, but ultimately there was no impact on the customer or the work. So in that case, we wouldn't direct any remedy. We just uphold the complaint, but we wouldn't direct the remedy. So what we do is, when we look at whether the service was reasonable, we look about what the consumer was complaining about. We determine what was reasonable in the circumstances and what evidence was available. So we would always, this is why we say it's important for us to scope the complaint at the outset to determine what it is that people are complaining about, so we can look to determine whether the service in that aspect was reasonable in circumstances. And we would ask the parties to make their comments and provide their evidence. So, you'll have the evidence when you get the first tier complaint, but you'll have the file, and you'll be able to look at what's happened and look at what the complainant is saying, and do your own investigation and determination of the complaint based on what you've got. So if you look at the complaint and you find that the service is reasonable, like I say, that's absolutely fine. Just communicate that to the complainant. Like I say, if you want to determine that it's basically reasonable, but you want to make a goodwill offer because you want to retain commercially, you want to retain the relationship, or you just feel that it's appropriate to do so, then that's a matter for your firms, but we wouldn't necessarily dissuade you from doing that, and we will take that into account when we get the complaint. So if something's like a bit of poor service, a bit of delay, and there's been a goodwill payment offered, then we would possibly consider that to be resolved at first tier, and we wouldn't take that case on for investigation. But in terms of where there has been poor service, if we determine that there has been, we look to see whether the poor service has led to any specific loss or disadvantage to the customer, and whether it's had an emotional impact on the individual. So there's two aspects of the loss. Sometimes the firm can do something or not do something which causes a direct financial loss. A common thing that's been complained about at the moment is the stamp duty window and firms delaying matters. So the stamp duty holiday was missed. So complainants coming in and saying, "Oh, we've had a stamp duty liability for several £1000s, and we think if the firm had progressed matters reasonably, we wouldn't have had to pay that." So that's a direct financial loss to us. Now, if we found that the firm had acted unreasonably and there was every chance that the completion could have been, transaction could have been completed before the deadline and should have been completed before the deadline, but it wasn't, firms didn't chase lenders, didn't deal with inquiries from the other side, so the completion got delayed, we may consider that that's a direct financial loss and look to direct the firm to reimburse that loss. It's that kind of thing that we're looking at. If there's if the firm's poor service caused a specified financial loss to the complainant. The other side of it is your traditional compensation, which is the effect that the poor service has had on the person, be it inconvenience, stress, upset, frustration, etc. And we have compensation guidelines on our website, which I'll talk about in a minute, and how we pitch those remedies. Like I said, what we always try to do in as much as possible to do so is put a customer back in the position that they would have been had there been no poor service, and we determine in that case what remedy will be appropriate in the circumstances. For example, if we were looking at complaints about advice and determining advising on the best course of action, we would bear in mind the fact that the firm is the legal expert. We'd also bear in mind that the customer is extremely outcome focused and wanting to get the best outcome that they can, be it, you know, compensation from an injury claim or the best possible result in court, either litigation or the criminal courts. But we would say that the firm have a duty to act in the best interest of the client, but the client should always be able to make informed decisions. So in terms of what's reasonable service on advice, I've got some examples of these. It was Mr. D working in the UK for 5 years, asked the firm to submit an application on behalf for indefinite leave to remain. So this is an immigration matter. The firm would advised it wouldn't be successful. It suggested a number of different options or alternative. However, Mr. D was adamant that he wanted to proceed. So the firm wrote to Mr. D explaining the requirements for successful applications and highlighting why the Home Office would be unlikely to reject the application. They explained he could try to appeal, but that would be risky and costly. Explained the risks of not resolving his situation before the current visa expired. The firm asked him to sign, say, understood the advice and confirm how he wanted to proceed. Now, he wanted to proceed with that application in any event, and then when he's unsuccessful, he brought the complaint to us. But we found when we looked at it, the firm provided full advice. He was advised of the risks. He was told that he could, if he wanted to proceed, he could do, but it was what the consequences of doing so. And that was him. Then he was in an informed position to proceed and chose to do so at risk. So we found when we looked at it, the firm's advice was reasonable, and we couldn't uphold the complaint. So that's an example of reasonable service. An example of unreasonable service and advice is and this was a lady a few years ago, instructed a firm in relation to a personal injury claim. They agreed to act under the no win, no fee claim agreement. After 12 months, she felt ill and decided she couldn't go on with the claim. The firm advised her they were disappointed and felt she had good prospects of success. They agreed to put forward a drop hands offer to the other side so both parties could work away at no cost. This was accepted. The firm filed a notice of discontinuance, but then 9 months later, the firm sent her a bill for their services, which amounted to £9,000. Well, they were entitled to do so under the terms of the conditional fee agreement, but where the service was poor was they didn't fully advise the lady of the consequences of discontinuing the claim at the time she did. You know, they wouldn't be able to claim the money off the other side. There was a breach, and therefore they were entitled to reclaim their monies. In that particular case, we found the service to be unreasonable because of the lack of advice, and she wasn't in an informed position when she chose to instruct them to put forward the drop hands agreement, and then she ended up with a £9,000 liability that she wasn't expecting because she wasn't aware. Now, obviously, she did have the conditional fee agreement and had the terms in it, but you know, we sort of recognise the fact that, you know, a lot of the time these people the customers aren't necessarily conversant with these types of agreements, aren't familiar with them. She hadn't been advised about it. She's been asked to sign it, and so she didn't know. So we then directed a sizable reduction in the fee. Well, based on the fact that, you know, she had made the decision, but the firm had done work that you know, that was of value, but it was just a case that she hadn't been advised of the consequences. In terms of determining complaints about cost, initial letters should explain the cost, what it includes. It's like I said earlier, with some matters such as litigation, it's okay not to know all the costs that will be incurred, and it's okay to request additional payment for additional work if that couldn't have been reasonably foreseen at the time of first instruction. This is an example of good cost information. Like I say, I won't read it out. It was one where there was a fixed fee, but additional charges were incurred, if additional work needed to be undertaken, and it sets it all out really. So it was very clear what the firm could be, the customer could be expected to pay. Conversely, this is some poor cost information. This is a fixed fee where it should be £1,200, but in fact, in this complaint, the person was initially billed £6,000 or more than £6,000 because there were all these additional costs in the second invoice that weren't advised in the client care letter. So it was unforeseen work required, and the firm just failed to advise the customer of this. And in this particular case, the firm would have reasonably known very quickly after they provided the initial estimate that additional work would be required and would be chargeable, but didn't ever tell the customer that would be the case until they issued the final bill. The costs were all valid, but the issue was that the complainant was never informed of what those costs would be. So they got a real shock when it came to the final bill. And what we don't like is to see people getting shocked with the final bill. They should be expecting what they're charged. So just a bit about options for remedies now, like I say, because we've got these examples of things that can go wrong. So this sort of sets out what we would consider by way of remedy. And apology is the first one. We rarely use these. I don't, as an ombudsman, direct apologies because I think by the time things get to me, it's just too late and it's just not worth it. And you would question the value of an apology if an ombudsman's directing somebody to apologise. And that's what we found in our own experience, that we get letters like from a firm saying, this is the letter of apology that the ombudsman directed me to write, or I'm writing to you to apologise because the ombudsman informed me that I had to do so, or the old classic, we're sorry if you felt that the service had been poor and the ombudsman determined this was the case, so here I am writing to you. And it's things like that. So you might find that appropriate response at first tier, but like I say, by the time it gets to us, that it's not something we would do. First tier remedies for firms as well. There's a possibility to be creative or personal approach. Flowers, vouchers. We did these back in the day, but when we first started, but we don't do them anymore. They cause more problems than they solve. We had a case where somebody was directed to provide the complaint with a box of chocolates, and then we got a complaint that it wasn't a big enough box, and another one we instructed directed the firm to provide a bunch of flowers, and the person came back and said there were flowers that they thought the firm had got off a graveside in the local churchyard, and it was just and they just caused more problems. The other one that we had issues with is charity payments. I dealt with a case where the direction was £500 and the lady wanted it to be made to Oxfam, and it caused real problems because then we had sort of evidence that the money had been paid to Oxfam. So now what we do is we say, well, if somebody wants a payment to be made to charity, we would say, that's fine, we'll give you the money, then you make the payment. What you do with the money is up to you. But the main ones that we do are the next three on the list, which is the financial loss, which is, like I say, the direct and provable loss. And I gave the example of the stamp duty that had been incurred as a result of the fact that the window had been missed. Another classic one for that is sort of late payment penalties on wills, HMRC penalties, if firms don't sort of progress matters and there's a tax charge incurred on that, then we would look to direct the firm to reimburse that loss to the estate. And these are direct and provable losses, and we can direct up to £50,000 for those. A refund of fees, we would determine whether the work's added value. A full refund of fees would only ever be directed if the work had no value or benefit to the client at all. That does occasionally happen, for example, if there's an immigration matter where the application made has been sort of completely the wrong application that had no benefit, no prospects of success whatsoever, and was bound to fail, and the client hadn't been aware of it, unlike the example I gave earlier on. We would direct a full refund of fees, but generally where the value of the work's been degraded slightly, we would sort of apply a percentage discount between sort of 10 and 30% generally, but sometimes sort of 50 and 75 in sort of extreme cases if the work's had very little value. The non-financial loss is the classic compensation, like I mentioned earlier: distress, inconvenience, time and trouble, etc. We have three categories for that: modest, significant, and exceptional, which I'll sort of talk about in a minute. It's included within our £50,000 limit, and it's usually £1,000 or less, although in certain circumstances we have directed larger amounts of compensation, and I've got an example of that in a minute for you. And we can also have the option to direct firms to put work right. Sometimes they'll want to do that. Sometimes complainants won't want to do that because the relationship with the firm is broken down, and we understand that. Sometimes it's better to just say, well, the work needs to be doing, but it's better for you to instruct another firm, and we'll set out the compensation at a basis at a level where you can go and instruct another firm to pay them to do that work. But sometimes it might be the case that things have just gone a bit awry and there's been a bit of a delay, for example, in producing estate accounts, and the firm say, well, we've got all the information, we can just do it. It might be appropriate to direct the firm to just complete the work they've started. Just to give you an overview in terms of poor service and no poor service, in all areas of law for all complaints in 2021, we upheld 55% of complaints. So that varies from year to year, but it's usually around sort of 48.52 to 45.55. We always upheld slightly more than we don't uphold, but there's not much in it really. And in terms of putting things right, 43% of all complaints is no remedy, but 37% is your traditional compensation, your non-financial loss. A fee-related remedy is 12%. 6% it's non-financial. Sorry, yes, and then 2% is putting things right. And I'd say we have the three criteria, three categories of award. Most of our awards are £250 or less, so they sit within the modest category. This is this sort of our guide to putting things right. It can be found on our website, and it sets out in more detail how we sort of determine complaints and what we sort of look at. But just to give you an indication, most of our complaints compensation is £250 or less, and that's where the impact was short-lived and no longer exists. If we find that there's more significant detriment, we would award £250 to £750, where it's serious but not permanent. And the serious detriment, we would award £750 plus, usually not more than £1,000. But like I say, we have done that on a number of occasions, depending on the impact. And for an example of that, where a firm disclosed the complainant's address to an abusive ex-partner, and then he ended up going round to her house, and she had to then move in sort of very quickly to get away from him, and that obviously caused a lot of distress. So just some examples of how we've determined poor service and no poor service. This is a case where Mr. F instructed a firm to deal with the purchase of a property and complained about unreasonable delay. And the Ombudsman concluded that the service was reasonable. This was one where the complainants had said that the firm's approach to determining where deposit funds had come from had caused a delay. What the firm had done was agreed that the screenshot of a bank balance would suffice, but when they received it, it didn't contain the complainant's full name and account number. So they had to then ask for further information to be provided, which did cause a slight delay, but it didn't affect the overall transaction. So we decided that overall the firm's service was reasonable, even though that they had to go back to ask for information. They couldn't have reasonably foreseen at the time that the information that would be provided wouldn't contain all the information that they needed. Another one, if we decide that our firm's cost information has been unclear, we could direct the firm to reduce or refund fees. A refund will usually be in proportion to the level of service. So this is case of Mrs. G. She was the joint executor of a late mother's will along with the firm, and complained that the firm's fees were excessive. The firm decided that the firm should refund 20% of their fees to the estate. This was a case where the cost of administering the estate ultimately ended up at about £58,000. There was no terms of business provided to the executor at the outset, no client care letter, no estimate provided at all. There was some just draft estate accounts produced after 10 months that showed that the firm had already incurred costs of £27,000. But again, at that point, they didn't provide any further estimate or cost information. They just carried on working. The reason that we decided it was 20% and not higher was for a number of reasons. Firstly, the work that the firm had done was perfectly valid and needed to be done in order to wind up the estate. And the firm and the executor had allowed them to do that work and had not queried herself what those costs were going to be, and not asked until she saw the final estate accounts where the deduction was made. So, you know, she didn't mitigate the position of the estate at any point herself by asking what was going on with the firm's costs. But the firm's cost information had been poor, so we determined that, you know, they should reduce their fees by 20%. If we decide there's poor service, we can award compensation up to £50,000, but in many cases a lower amount is awarded. We aim to recognise the impact and frustration that poor service can have on a person. Mr. H, in this case, instructed the firm to represent him in a noise-induced hearing loss claim against his former employer. He complained that he was not informed when his case handler had changed, information was lost and the file was passed over, his claim was not sufficiently progressed, and the firm were unprepared for a hearing. When we determined the complaint, we found that the handover of files and case progression had been reasonable, so the matters had progressed in a reasonable manner, but the firm hadn't done enough to make him aware who was handling the case. So what I mentioned earlier about case handlers being sort of passed from one to another people, and he wasn't really aware of who was dealing with this case. So we concluded that nobody was, which wasn't actually the case, but the communication had been poor. We found that there'd been no impact on the claim itself, no direct financial loss. Eventually, this chap was successful in his claim, but we awarded £200 compensation for the fact the upset and frustration caused by the fact that the firm's communication being poor with regard to the handover. So we do, like I say, award as well, higher awards of financial compensation, which can be made when it's clear the impact of the poor service has had a significant negative impact. So this lady, Mrs. S, complained about a firm she'd instructed in respect of a sale and purchase. The sale had been completed and funds for purchase had been transferred to the firm's account as agreed. They needed to complete the purchase on her behalf so she could be in before Christmas. The firm caused an unreasonable delay, which meant the funds remained in their account and the completion did not take place. As a result, Mrs. S and her family spent Christmas in a caravan on a parent's drive. Immediately after Christmas, the firm's accounts were frozen by the regulator. It took a considerable amount of time for Mrs. S to get her money back. She also lost the purchase and had to move into rented property. She suffered considerable losses. In fact, the losses that she suffered were in excess of £8,000. Those were the direct financial losses as a result of the fact that she had to she wasn't able to move. Then she lost the sale and had to sort of find another property, and then she had to move out the caravan and go into sort of rented accommodation till things were resolved. And the matter had been exceptionally stressful for her and her family, and as a complainant she was extremely stressed by it all, and we awarded £2,500 in compensation for that. That's probably one of the most I've ever encountered. It was sort of it was exceptional circumstances given what had happened at the time and the effects that it had on the lady. So that's give you a bit of a whistle-stop tour about some of the complaints that we've looked at and how we determine poor service and no poor service and the remedies that we direct. And like I say, if you look on our website, there's resources on there it's called Our Guide to Putting Things Right that you can sort of use to pitch your own remedies. Again, what I would say to you, if you're dealing with a complaint, you're not sure how to pitch a remedy, or you're not so sure whether something is poor or not, use our technical advice line. Let us know what the issue is, and although we can't sort of determine the complaints because we don't have the evidence, we can provide you with sort of high-level guidance and advice on how to deal with matters that will be hopefully helpful to you. So just something to bear in mind. But what we wanted to talk about a bit about is case fees, because again, this is sort of something that firms find confusing sometimes and don't understand how it is that we work and think that we're just there to sort of generate income and charge them fines. It's not the case. Legal Services Act 2007 says that the case fee must be charged. A case fee is applied at the point where the case is accepted for investigation, and it continues to apply unless it's disapplied, and it's only disapplied in circumstances where under our scheme rule 6.2, the complaint is abandoned, withdrawn, or settled, resolved, or determined in favour of the authorised person, and the Ombudsman is satisfied that the authorised person took all reasonable steps under his or her complaint procedures to try and resolve the complaint. So we don't really have any discretion. This is very rule-based. We have to sort of look at what's happened. If the complaint's response has been reasonable, so the signposting has been, the complaint's response has been given in a reasonable time, the signposting has been done, then that satisfies 6.2b. But in terms of the resolution, I mean, obviously if the complaint's abandoned or withdrawn, that's a different thing. But if it's settled or resolved and determined in favour of the authorised person, then we would disapply the case fee. Now, in favour of the authorised person can mean that if you offer a remedy at first tier, say a couple of £100 goodwill, and we look at it and determine that it's reasonable, and we uphold it and we endorse that remedy, then it's still settled in favour of the authorised person, because we're not beating that offer. So that's something that we would use. We would be able to disapply the case fee at that time. It's also worth saying that if you offer nothing at all, and then we determine that even an apology would be appropriate, or it's a bit of work to put things right that doesn't really have any cost, but it involves extra that isn't offered at first tier, we don't have the ability then to disapply the case fee, so it would apply. So it just, like I say, just think about at first tier what's reasonable, and if you want to apologise at that point, apologise, or to put things right or make goodwill gestures. Appreciate you might want to do that, but it might be justification for doing it on a commercial basis to try and resolve matters. But we will look at complaints when they're coming through to us to see whether an offer's been made and whether we could determine that to be reasonable. Because, like I say, we at that point, the way that we're set up at the moment, we're not taking on those complaints. Or if something comes through to us and then we determine later on that there's been an offer that's open for acceptance still and is reasonable, then we would look to dismiss that under our rule 5.7. So that's just worth bearing in mind. But case fees aren't chargeable in certain circumstances where the complaint comes to us and it's premature, the firm hasn't been given a chance to respond. That if it's outside our time limits or outside our jurisdiction, if the lawyer's not in jurisdiction, or if there's been no legal service provided. Third-party complaints, so against the prosecuting lawyer in a court case, for example, where the service hasn't been provided to that person. Duplicate case or signposting, they don't generate a fee. And we have the ability to waive cases as well where a complaint's resolved without investigation. We haven't seen poor service, or it's been unable to proceed, or a complaint's been withdrawn and we haven't seen poor service at that point, or it's been resolved by agreement or case decision, or it's been accepted. Ombudsman's decision has been accepted by the complaint, and it's been determined in favour of the service provider, or it's been dismissed under Rule 524, 562, where the complainants failed to provide an response to our correspondence, so they've disengaged. So that's a bit about case fees. Final bit is managing challenging customers, because we do get a lot of questions about this when we go out and about with people. We get firms come to us and say, you know, we've got this particular customer, they've been very difficult. They may be threatening, they may be shouting, they might be communicating with us excessively, and how do we go about dealing with that person? You know, we're aware that there's sort of mental health issue effects on solicitors and people within firms that are dealing with those people, and we're very used to dealing with them. So we sort of like to sort of provide these sort of best practice tips in terms of dealing with people like that. It's always good to have a clear process in place about how you deal with matters, and things you might want to include is what does your firm consider to be unacceptable behaviour? Is it somebody shouting, swearing, excessive contacts, like calling you 10-15 times a day, and what that looks like? And then just have a policy on how should staff respond if they're faced with an acceptable situation. When do they take action? And think about why the customer might behave. We deal with a lot of customers with mental health issues where this is a problem, but equally people are very angry and upset, and that might generate that or sort of cause that behaviour. We would also say have support in place for staff who might be dealing with those sorts of situations. We do that within the Legal Ombudsman, we get sort of people calling us up who are very sort of angry and aggressive and shout and swear and all the rest of it, even threaten us. I mean, I've had death threats as during the course of my job, and that's not uncommon. And we sort of have processes where, you know, people can take a 10 minutes away, or they can sort of refer it to a wellbeing champion or whatever if you have those, and get help and advice on how to process things and deal with things. And it's that sort of support network that we find is very important for staff to be put in place when they're dealing with these sorts of issues. Document the process. And the last one, which is the one that I wanted to sort of stress the most, is use the Legal Ombudsman if necessary. Now, that again, it might seem counterintuitive, or we don't really want the ombudsman to be dealing with things, but if you're getting somebody who's continually phoning you up, shouting and screaming and being aggressive, push them through your process and send the final complaint response, and then you don't have to deal with them anymore. You can send them on to us, and then we'll deal with them. So we don't want to expect firms to be sort of continually having to have long, difficult conversations with people who are very challenging. The intention is that you instigate your complaints handling procedure, you deal with your complaints handling procedure, you provide the final complaint, and then you send them on to the Legal Ombudsman if they remain unhappy. But you don't have to continually have to deal with challenging and difficult customers. So that's just a bit about what we would advise. Really, just have a think about how it is that you deal with this sort of circumstance, because it depends on the area of the law that you're dealing with. We find that certain firms deal with sort of landlord tenant criminal matters, are more likely to have to deal with that than somebody dealing with, for example, wills and probate or conveyancing. But it's always worth just having a think about, you know, if you come across these sorts of customers and these sorts of issues, how you deal with them. So that's really what I wanted to talk to you about today. Like I say, in terms of feeding back to the profession, you can talk to an ombudsman through our technical advice line, which is technical.advice@legalombudsman.org.uk. I man that, so if you send a question or a query or any feedback that you want, or anything you want to talk about, just send an email through to that line, and I'll get back to you within 5 working days. And we've done a variety of things with people. We've looked at their complaints handling procedures and sort of given advice on whether it's appropriate or not and how they could improve it, or they've had sort of specific issues with specific complaints that we've sort of given advice on. For example, we think this is a negligence complaint, what do we do? And we have issues like that sort of arising that we can provide help and advice on. We do sort of aim for our website to be informative, providing guidance, data and thematic reports that will be of interest to the profession as well. And we do sort of training and events. I do a sort of a longer half-day course on complaints handling, where I can go into more detail than I have done today on sort of the end-to-end aspect of complaints handling. So keep an eye out for those, and sort of they're fairly reasonably priced. You can book onto them, and we sort of try and do them all over the country. We haven't been doing them over the pandemic, obviously, but we've had some online courses. And you can sign up for Leo News, which is our sort of online newsletter, which is on our website. So that's it anyway. Thanks ever so much for listening to me today. And if you've got any questions, please fire away. And like I say, look at our website. We've got all information and guidance on there for you to look at. Thank you.
Jason, thank you very much. Apologies, I've asked my video to start, but it's refusing. So you'll just have my voice in the background. But thank you very much. That was a really thorough talk, jam-packed with useful tips and advice and information. And I know that we've got some questions, and I've also got a quick question about the technical advice line. If people ask questions through that, to what extent is that confidential and linked back to any future query or complaint? Not
linked at all, and we would treat everything as confidential. I mean, we've had questions about I had for example a barrister who was going for silk, and he had a complaint and he wanted to sort of details on how to handle it, so his silk application would be adversely affected, so we provided advice on that. But obviously that was very, very confidential. And we have complaints where, you know, queries rather, where the complaint is quite confidential in its nature, so we advise on it, but absolutely confidential, and we don't link it to any complaint going forward. So any advice that we provide is just based on what we're informed. So
that's wonderful. Thank you very much. That's really helpful. Right, I've got one question that's just come in the chat, saying thanks, Jason. Does the Ombudsman charge a fee for handling a complaint?
No, it's by way of the case fee. Like I say, every time we get a complaint for investigation, the £400 case fee applies until such point that we can disapply it, which is for, like say, for the reasons that it's either abandoned or withdrawn or determined in favour of the service provider. And if the complaint handling has been reasonable, no fee to the service provider at all. Obviously, we're in an ombudsman scheme, so we can't impose a fee on the complainant, but that's the way that it's funded.
Lovely. No, that's really helpful. I hope that answers your question. One here on the chat from Lucy, where it is not clear what remedy the client is seeking, is it good practice to invite them to put forward a suggested remedy by phone or email, or should a firm always make the initial proposal?
No, I mean that's a really good point, and it's sensible for just ask them what they want. You might find that what they're asking for is unreasonable and unrealistic, but at least you've got an idea. But yeah, I mean, what we're saying is when you respond, try and pitch any remedies in line with us, because then we can say that the offer was reasonable and think about the impact and the effect that it's had on somebody and pitch it accordingly. But certainly, yeah, I mean, it's a good way to resolve things, saying, well, what is it that you want? Because, you know, it might be just the case that a couple of £100 might do it, and you might think, well, that's reasonable in the circumstance, we're happy with that, and it can just shut things down. But you know, yeah, I definitely advise, you know, if you're not sure what they want, ask.
Yeah, I mean, that certainly makes sense when you look at some of those the levels of compensation that the most often given. It is in those small amounts, isn't it? And
absolutely.
To go through that whole process and just the time it takes for all those involved. Again, it could be a simple way of say shutting it down and moving on. And next question, how does the Legal Ombudsman deal when a firm provides a response to a complaint outside of the 8-week time limit, but it has a reasonable reason for the delay, such as staff shortages or capacity issues due to COVID? I mean, obviously COVID.
It's a great question. What we if that's the case and there's good reasons, then we wouldn't make an adverse finding. What we would expect is if that was the case, we'd expect sort of a holding email just to say, you know, we're not going to be able to respond because these are the issues. And we have had that. You know, we've had, like you say, furloughed staff. In Wales, people didn't have access to their offices and the paper files were in there, so they weren't able to respond to the complaints. But, you know, when they've advised the client that this is the situation and we'll get back to you as soon as we can, but we won't be able to do it for these reasons. We were always hearing the phrase unprecedented times, weren't we, during the pandemic, and we recognise that as well, and that's affected how we've sort of dealt with complaints. And we did provide some COVID guidance back in April 2020 on how firms should deal with matters and what they should do. It's still on the website now, but what we did sort of take a more sort of common sense approach as to recognizing that there were difficult times for everybody's, and you know, it might be the case that, you know, you want to respond to a complaint, but the files in the office that you're not allowed to go to without breaking COVID rules. So that's that we are mindful of that. Yeah,
that's helpful. And I guess as ever, it's about communication, isn't it? Just
absolutely
people informed of what's going on from all sides. And another question, how does the Legal Ombudsman deal with vexatious complainants, and does it have the ability to charge the public for wasting time?
Yeah, no, we don't, unfortunately. No, we do have a rule within our scheme rules that allows us to dismiss a complaint where we determine it to be vexatious. It's not something that we've particularly used in the past, because it's quite difficult to determine. If somebody's made the effort to sort of raise a complaint and to bring the complaint to a firm, then it's difficult sometimes to say that it's vexatious, and it's not just them being really unhappy and unaware of, you know, the situation. That being said, we have had cases where it's clearly vexatious. We had a complaint where the chap didn't get what he wanted, so he complained that the bin hadn't been emptied in the meeting room. So, you know, something like that, it's like, well, you know, there's no detriment there, but we dealt with that by use of our scheme rule 5.7 and just dismissed that complaint. So we do have the ability to do that. And we do sort of look at things like that. We had a chap a while ago who was upset with the firm and just kept bringing individual complaints. He just sort of sliced up his complaint and brought a complaint of delay, then a complaint of costs, then a complaint of failure to advise. And in the end, we just said, well, this is clearly vexatious. We're dismissing this and we're not looking at any further complaints. So it is something we're mindful. But firms can always challenge us under our scheme rule 5.4 to say, you know, if they think the complaint has been brought on because by a vexatious complaint, it's a vexatious complaint, then they can ask us to look at it, and an ombudsman will determine whether they, in the circumstances, think that the complaint is vexatious, and if that is the case, then they will dismiss it.
Yeah, I mean, I think that slightly leads into this question, albeit I can see that this could also occur where you're not dealing with somebody who's necessarily vexatious, but maybe who comes back at a slightly later date. Would you accept a complaint where the client has already agreed and accepted compensation as the resolution?
No, I mean that's just not fair. I mean,
yeah,
if the complaint is, what I would say is, if you're making these sorts of offers and they're accepted and they're intended to be in full and final settlement, say they're in full and final settlement in the final complaint response, and then there's no doubt. But we've had cases where it's not really very clear whether it's just an interim offer or it's in full and final settlement. But if somebody's accepted a resolution to a complaint, a financial resolution, and decides to come to us for a second bite of the cherry, as it were, we don't accept those, because it's just not fair on the firm. They've made a reasonable offer, it's been accepted. Why are we involved? So we don't accept those. No.
Okay, that's really helpful. Thank you very much. I think it's our final question. So if anybody else has got another one or two that you want to get in, we've got just a couple of minutes left. We'll get them in quickly. So would the Legal Ombudsman consider a complaint from a residuary beneficiary about failure to provide cost information when the firm's executor client has instructed the firm not to provide updates to them?
Yeah, this is a tricky one. Yes, we would, but equally we wouldn't expect firms to be providing full estate accounts. We determined it to be reasonable if somebody's saying, well, what's this going to cost the estate? That high level information is provided. But what we also find is that residuary beneficiaries get involved and say, oh, we want full estate accounts, we want to know exactly where what bills have come in, what the assets and liabilities are. We wouldn't determine that to be reasonable, and we'd say, no, you'd really, that's for the executor, you haven't, and the firm who are administering the estate, you haven't really got the right to that. But equally, if they were just saying, well, we just want to know what this is costing the estate because I want to know how my share is going to be affected, then yes, we would expect that information at that level to be provided.
Super. Oh, we've got somebody raising a hand. Oh, I've never had a raised hand before. And let me have a quick look at that. I'm not sure who that is who's raising a hand. Apologies if I'm trying to see. Let's have a look. I'm not sure that's another question. If it is, please do type quickly and I'll try and get to that. Apologies, I can't see where that's coming from. Just to say, to respond to one of the questions in the chat, we have recorded this, and Jason has kindly agreed that we can send that out, and we put it on our YouTube channel. So again, by all means, if you want to watch it again, and if you think it's going to be good for your colleagues, I'm sure you'll be delighted that the more people watch it, the better, Jason.
Yeah, certainly. Absolutely.
Fantastic. Here we go. Last question, I think. If a client says they are not happy with the general handling of their claim, is it reasonable to go back to them and ask them to be more specific in terms of what exactly it is they were not happy about, so we can...
Yeah, I mean, how are you going to, I mean, not happy, that's just so wide. I mean, how are you going to determine that? I mean, you definitely, I mean, we have these very vague complaints coming through to us. We have to scope them and sort of narrow the scope so we know what it is we're looking at. So just unhappy with the outcome, or unhappy with the way that the claim's been progressed, well, what does that mean? Does that mean communication? Does that mean delay? Does that mean you're not happy with the settlement? Yeah, absolutely. We wouldn't expect a firm to be able to determine that complaint because it's just too wide. You don't know what it is. So it's reasonable to go back and say, yeah, but what is it that you're complaining about? That's absolutely fine.
Wonderful. Oh, right. I think this might just have to be the last one because I'm conscious that we're coming to 2 o'clock and people may well have other meetings in their diary. But would you say yes, we will provide slides from the webinar along with the recording, so that will come to you in the next 24 hours. Would the Legal Ombudsman say that the firm acted unreasonably if they did not provide the res-bens with cost updates, residual benefits, sorry, beneficiaries with cost updates in accordance with the executor client?
Yeah, no, I don't know. That's absolutely fine. We wouldn't expect cost updates to residuary beneficiaries. Like I say, if the residuary beneficiary just wants to know what the likely costs are going to be, just on an estimate basis, to say, oh look, I think the residue of the estate's going to be about £10,000, but I want to know what the deduction is going to be. So, for a firm to say, well, our overall fees are going to be 8,000, there's 4 of you, so it's going to be about 2,000 each, then we'd expect that level of, but certainly not sort of regular updates, not sort of detailed estate accounts, nothing like that. That's beyond what we would expect a a firm to provide to a residuary beneficiary.
Wonderful. Thank you very much indeed, everybody. Thank you, Jason. We've got a few people thanking you for the content of this presentation. As I say, it's been really, really thorough, and I think, you know, that the slides and also the ability to rewatch it again will be really useful to people. So thank you again. We've got obviously your email, so if people need to contact you, I think they can do so.
Yep.
And to everybody, thank you very much for taking the time to join us today. Please spread the word to your colleagues and risk teams, etc. If you think this would be useful information for them as well. I'm sure you know, there'll be some tips in there that everybody can take away. So thank you everybody for your time today, and we look forward to seeing you at our next webinar.
Thank you very much. Thank you.